Thank you for joining us today. I'm Joseph Benesi. I am the chair of Florida Rights of Nature Network and the communications director for Florida Right to Clean Water.org, the two organizations that are behind this effort to amend our state constitution with a fundamental right to clean and healthy waters for all Floridians. And this is the third of 4 planned FAQ sessions in which we take a deep dive into our amendments and deal with any questions that folks on the call might have, and we even have some of our own. These are questions that have come up very often when we are out in the public talking to potential voters, presenting to groups and such. We have 2 experts today, I hope, definitely one, and potentially another. She's on the road. The first is Mel Martin. Melissa is a Florida attorney and Florida native. She has a Bachelor of Science degree from the U.S. Naval Academy in Annapolis and served as a commissioned officer in the U.S. Marine Corps. A few years in, she earned her law degree from Barry University School of Law, where she had the privilege of taking classes with Professor Coons, Emerita Law. In 2014, she retired as a Marine Corps Staff Judge Advocate and moved back with her family to Brevard County, where she advocated for good government, environmental conservation, and clean water in various leadership roles. She taught at Barry Law School as an adjunct law professor on the subjects of water pollution law and environmental ethics, and she recently moved with her husband and children to Eugene, Oregon, from where she telecommutes and volunteers her time for the success of this initiative. Mel, thank you for being here today. And the other person who we hope to have on the phone call is Maya Van Rossum. She is in transit today. She had a very important meeting in New Mexico that she is returning from. But Maya is the founder of the Green Amendment for Generations movement. That's a nationwide movement. She is the Delaware Riverkeeper and leader of the Delaware River Network. I think she's been a riverkeeper there for 30 years. I think she might be the longest serving riverkeeper in the world. She is the author of the Green Amendment, The People's Fight for a Clean, Safe, and Healthy Environment. That's the 2nd edition. It came out this past November. And she is the author of the Green Amendment, Securing Our Right to a Healthy Environment, which preceded that. I'd also like to add a few other things that I find particularly cool. She was announced as the 2020 River Hero by River Network. She received the Giraffe Hero Award, given to those who have the courage to stick their necks out for the common good. I don't know who gives that one out, but I like that one. She has testified by invitation 3 times before the U.S. Congressional Committee, and she founded the Environmental Law Clinic at Temple's Beasley School of Law. So if and when she's able to join our call, we are very, very happy to have her. Before we jump into some questions, I just want to provide some context so everybody appreciates just why Florida Rights of Nature Network and Florida Right to Clean Water.org are pursuing this constitutional amendment. Well, we have approximately 1,000 springs in Florida. 80% of them are impaired. Many of them are suffering very significant reductions in flow. According to the Florida Springs Council, a very reputable organization, given current projects, it will take over 200 years to clean up some of these springs. We have nearly 1 million acres of estuaries and 9,000 miles of rivers and streams that are contaminated with fecal bacteria. No state in the nation has more acres of polluted water than does Florida. No state has lost as many acres of wetlands as has Florida, 9.3 million. Red tides, which are a concern right now down here in Southwest Florida where I live, have exploded in the last 25 to 30 years. We have had about 200 months of red tide. In the previous 120 years or so, there were only 64 months. I live in Cape Coral. Blue-green algae is a big problem here, as it has been elsewhere in the state. You probably saw photos from back 2019 in which our canals were just choked with blue-green algae. And we had literally tens of thousands of tons of dead sea life on our shores to haul away. There are 50,000 tons of legacy phosphorus sitting at the bottom Lake O, exacerbating those blue-green algae blooms. And over the course of the last 50 years, this state has issued 23,000 permits to polluters to pollute the surface waters of our state. That's 10% of the nation's total. Our system isn't working. We need a corrective. This amendment is the corrective. So we have a number of folks on the call, and we don't have all that many, so it's easy to have a nice little conversation. If anybody on the call has a question that they would like to ask first, I welcome you to ask that question. You could just raise your hand visually or put up your digital hand. Okay, well then I'm going to ask some questions that are commonly asked. And we may have, Mel, we may have dealt with some of these in the previous two FAQ sessions, but they are so often asked that I think it's worth returning to those. Perhaps more than anything else, people fear that this is going to lead to an excessive number of lawsuits. Lawyers are going to see dollar signs and they're going to encourage as many lawsuits as possible. Is this a legitimate fear? Are we going to have lots and lots of lawsuits because of this amendment?
It is definitely one of our top frequently asked questions. And I'm not sure about you, but this 3-second delay on my video is a little annoying for me. If you don't mind, I'm going to stop my video so I can just talk plainly. Okay. The bottom line is that there are many different measures in place to prevent not only litigiousness or frivolous lawsuits, but lawsuits that are just not going to do good, do good for what we're trying to do here. The inherent basis of our amendment is that it's a public interest law. It's not for personal monetary damages. It's not about, your personal property, your personal injuries, or things like that. There are already laws out there for that. Plenty of tort laws. But what this is more of a correction mechanism for the use and purpose of Floridians themselves, the people that benefit directly from clean and healthy waters. So you have your individuals, you have your businesses, you have your local governments and nonprofits and all the above, tribes, people who are dependent on clean and healthy waters have the ability to correct a bad government decision. So it's really incumbent on the government itself, on the state agencies, to abide by, comply with the constitutional standards, right? So in essence, when you step back and you look at this for what it is, the only time you're going to be able to use the amendment is when the government decides to intentionally, knowingly, and go, have an action or inaction that is unconstitutional. And again, the standards are clear. The standards are very clear in the Constitution. I recently made a point on social media that another measure that will prevent any, this litigiousness fear or floodgates fear is that government attorneys are how things work in the government. No action, especially no big or controversial action, takes place unless you have an internal memo from your OGC, your Office of General Counsel, an assistant attorney, someone who looked into the matter, looked at the laws, looked at the level of discretion that your decision makers have, and gives it an official thumbs up that yes, you can do that. Okay, those government attorneys have been working up until now with laws that are very deferent, and there's a wide discretion for these decision makers. That's how things been going on. There's, the spectrum of good decision, or the spectrum of decision making can be good under the right I would say, political climate, under the right culture of, how things should be prioritized, or on the other side of the spectrum is what Florida has been seeing in its recent history. If they can, they will type of thing. And so the fact that there's going to be a constitutional, clear and specific standard, legally enforceable standard in place will ensure those government attorneys, when they take a look at the issue, will say, no, you can't do that. That's unconstitutional, unfortunately. And there's not going to be litigation because of that particular mechanism in place in the system. So that's the inherent and comprehensive answer. The anecdotal answer comes from Maya, who has seen how the Green Amendments are treated or are, what the dynamics are in at least 2 or 3 other states now. And from her research, from her personal and professional observation, there is no floodgates. What cases do rise to the top need to be litigated. Some kind of harm needs to be stopped, but it's by no means anything near the idea of floodgates of litigation. So all those, there's many other reasons, but those are the top reasons why.
Thank you. We have 2 hands up, but just before I call on Carl and then Marilyn, I just want to note to everybody here, full disclosure, that Mel is one of the primary drafters of the amendments. Just want to let everybody know that. Go ahead, Carl.
So Mel mentioned tribes. Here in Florida, we have several tribes. I know they took a position of neutrality when we were pursuing rights of nature initiatives, because the way they view nature is a little bit different than our perception of rights of nature protections are. But have any of the tribes weighed in regarding this civil right to clean water? Have we heard from anybody in the tribes regarding that?
I know there is discussion going on. The Reset Center in particular has been having a lot of conversations with folks down here, Miccosukee tribe, some of them, certainly not all of them. They're still taking that position. We're hopeful that there might be a change.
Hazard reported ahead on I-75 south, 3/4 of a mile. You're still on the fastest.
And I wish that I recall an answer given to this question by a woman who was married to a Native American, a Seminole, and she gave a very good reason why it hasn't happened yet. But Carl, we're still working on it. I think the possibilities here are more promising than they were with our rights in nature efforts. Marilyn, you have a hand up, a question? You're on mute.
I'm sorry. I'm in
That's okay.
Brevard County, which of course, Titusville had our right to clean water petition being challenged. So I wanted to know about how to answer about, is any of this retroactive, and if there are impacts that, of course, something happened years ago and we're still feeling the impacts of some kind of city action. Can the lawsuit be brought against the city? And of course, then the question is, then people are going to say, how much will this impact my taxes?
Yes, both are very good and valid questions. So to answer your first one, the amendment cannot be used for past actions or past inaction, even though we're still feeling the impacts today. So what it can be brought against are current or potential, something that's on the chopping block type of potential, applications for permits or whatever, those types of actions, or policies, deliberate policies of inaction that are that are in place now that they're, making today, or, when the amendment becomes effective and it causes harm or it threatens to cause harm, yes, you could use that. So if there is a source of pollution that may have started 5 years ago and it's still going on, and, should this be enacted in November of 2024, still going on, it's game. You can bring it to court as a current action that is causing harm to protected Florida water.
Okay, so the city of Titusville built over their well fields 20 years ago. So this is not something that we can take any action on, obviously, right?
Correct.
Okay.
The building of it, whatever happened before, yeah.
But you said that, but the impact is still ongoing. So I don't understand the distinction between something that's currently causing. I mean, they're still continuing to allow building on the well field. Could we halt continuing building on the well field if they proposed a new subdivision?
If the plaintiff is able to show that there is going to be harm or threat to harm the water, yes.
Mel, can we clarify that actually the city itself could not be the object of a lawsuit?
Right. Thank you, Joe. So in Titusville's, I crossed the streams there because Titusville does, under its charter amendment, once it gets, once the fog clears, you're able to go after the city with a similar right to clean water type of action. But for the purpose of this amendment, whatever permit or policy or regulation from the state that allows the city to do this or that, you can go after the state because that particular regulation or rule or permit or delegated authority or something is threatening a protected Florida water.
Okay, so we can't go after counties or municipalities. It's only impacting state level, like the St. John's Water Management District or something like that.
That's correct. Under this amendment.
Okay, thank you.
Yes, and to talk to the taxes issue, that's another good one where you have to kind of zoom out to see the full picture. Now in the front end, well, I would say zooming out helps to see the whole picture from the front end on. The bottom line is that we're already wasting hundreds of millions, billions on restoration projects for waters that have been impaired that, based on preventable pollution, things that we could have prevented before had we had the right political climate to say no. And so this is a stopgap. It says, okay, no more of that. And over time, nature has a tendency to heal herself. So there will be less need for taxes to be allocated for the purpose of restoration and cleanup. You have that. You also have connected to the first question regarding less litigation, ironically, versus more. With less litigation, there's more budget available to take care of this or that. So it's the money game at the state level, especially, is very enigmatic to begin with. But there's no indication that this is going to cost the taxpayers more for the state to do its job based on pre-existing duties. But you have the propaganda machine that'll tell you otherwise, likely. But so hopefully people, when they hear those types of points meant to generate fear or lack of support, they'll be savvy enough to ask the questions of, let me see your budget, let me see what you're talking about. Because once you start asking those questions, that the floor falls out. So it's a good question. It's a big question. So it'll be interesting. Part of the Florida Supreme Court's review is to look at the economic impact of proposed ballot measures. And we not only plan to talk to the legal aspect of our ballot measure, but also the economic impact of it. So to make sure that it's accurate and shows all of the math involved.
Thank you, Mel.
Mhm.
I was thinking about the governor's recent $3.5 billion package to clean up and restore a lot of our waters here in Florida. Taxpayers are footing that bill?
Yeah, yes. Yes, they've been footing, like I said, annually, billions and billions of things that could have been prevented if it costs $0 to say no, to
Yes.
say no to a bad permit application.
So when the Supreme Court does that economic analysis of the impact that the amendment would have,
Mhm.
I presume that takes into account the impact of not having the amendment, the cost of continued pollution.
I hope so. We're going to make sure that it does have a fair estimate of all costs associated with yes and no.
Terrific. Thank you.
So David had a question in the chat.
I'm sorry, I did not see that, David. David, you want to just ask it? Or Mel, if you already know what it is?
Okay. He says that the Florida Springs Council just won their case against Florida Department of Environmental Protection to force them to write adequate BMAPs, which will actually work to reduce pollution. We have adequate laws protecting our environment, so when legal action can be taken to force the state to do its job and enforce those laws, why do we still need a constitutional amendment to protect our water?
Excellent
So,
question.
yeah. And again, that is also one of our top questions of, don't we have enough laws? And the quick answer is, looking around, no. The evidence speaks for itself. Can there be a dramatic rise in litigation to go after the state and every single one of their decisions affecting every single water body that is protected? Sure, but why not? That's a very tough haul from the bottom up. Why not from the top down clarify what our standards are so the government can comply with them and implement them from the top down without cost, without unnecessary litigation, telling them that they're wrong all the time. And I love that the Florida Springs Council and others associated with the case won. It was a glaring error, and it was one of those things that confused me how it could have gotten that bad. But again, it goes back to the wide discretion that state agencies have. That, in fact, I think I just looked at this on my phone. Let me take 2 seconds to see if it's still available for me to look at for you. The fact is that they had for 4 years continued with the position that they didn't have to. Okay, here it is. Yeah, I'm just going to read it to you. For 4 years, the Florida Department of Environmental Protection took the side, and this is from the Florida Springs Council's press release today. For 4 years, the FDEP took the side of polluters in court. DEP argued that the BMAPs did not need to actually achieve water quality goals. Sorry, I'm pausing for effect.
Yes.
They only have a target for doing so. That they did not need to assign pollution reductions to categories of non-point sources, and that they did not need to offset the inevitable increases in pollution from future growth in both population and agriculture. So they were looking at a very warped interpretation of the law and saying, no, we don't have to do that. Even though the law clearly said so, right? They said, no, it just means we have to have a target. It doesn't mean we need to go after that target. And so for a very long time, they decided on, hey, this is the way it is. And it was so egregious. And what's unfortunate is that you only find these wins when the cases, the facts of the case are just so obvious and so egregious, much like the Act 13 in Pennsylvania that Maya had been talking about before. But in this case, it was just sadly obvious that the court had to fight against DEP. So the laws are there, but they're unfortunately giving way too much discretion to state agencies to interpret them and implement them. The need for a constitutional amendment, not just a constitutional amendment, but a very specific and clear standards of, what you can and cannot do. What is harm? What is a clean and healthy water look like? What are the indicators of that? Those types of things in court will ring much differently than what normal litigation, environmental litigation is all about. So this is a win, but it's a small win. I'm sorry to say, it's not a systematic win. It's not going to necessarily copy and paste to all other water bodies in Florida. Should it? Sure. But if the FDEP is in its, again, captured by its political climate of do things for the polluters first, then they're going to continue to drag on. I didn't see the court order, so I don't know what timeline is involved, but it did say that their BMAPs had to be overhauled for just about everything within the spring system. So that, how many years does that mean? How long are we going to have to wait before we find their next draft of a BMAP? It says immediate, but how long is that in government terms? So that's a long way of saying that we have good laws if the right people interpret them and enforce them. And so this amendment just closes that systemic error, that gap, and says, okay, people who implement and enforce, you have to do better. You have to do it by this standard from now on.
So Jim had pretty much asked the question that you just answered. What difference would it have made if we already had this amendment? But if we did have this amendment, the DEP never could have made that argument to begin with,
Right.
Because they're simply not permitted to violate our fundamental right to clean and healthy waters.
Exactly.
They couldn't go through some sort of crazy contorted arguments about not living up to their own, BMAPs.
Right. Exactly.
Okay.
Can I add something here?
Of course, David, go ahead.
Yeah, as it stands, I think there is nothing to prevent. Well, there is something to prevent from getting the legislature to rewrite the BMAPs, because I believe that there's a federal content of those BMAPs. But I still think that it would be possible for the Florida legislature to write some law to allow FDEP to avoid that altogether by saying that our BMAPs are going to be different from the federal BMAPs from now on, and here's what they're going to look like. Or they could also come back and take this to the Florida Supreme Court, and the Florida Supreme Court, might well rule, in the same fashion as the district court and the administrative court of Florida did, and say, oh, well, FDP is right. We really can't expect them to do the impossible. They're doing the best they can. That's it, so.
Yeah.
The amendment would, of course, not allow all of that to happen.
Mel, can you speak specifically to the fact that this is a fundamental right and what that means about strict scrutiny from the court?
Sure. The courts generally have two ways of looking at an issue when you're talking about a right. One is a rational basis. If the government does something that infringes on your right, they just have to be rational or legitimate in their interest, saying, you know, this is good for a private corporation, so therefore it's good for the local economy, therefore good for the public interest. And it can be as that, you know, that superficial, without having to do any more math than that. And when you're talking about strict scrutiny, that can only happen when you use the right words and you place the law in the right position. For instance, in the Bill of Rights section in the Constitution, then the courts have to, and every lawyer knows this, every first year lawyer, I mean, law student knows this, that you have to use strict scrutiny, which means that whatever the government is doing, it has to be serving a compelling government interest. Compelling is not just any old interest. It has to be compelling. That is also narrowly tailored to serve that interest, meaning you're doing your darndest to prevent any unnecessary harm or threat of harm in whatever you're doing. That type of scrutiny, you would think is automatic, you know, but it hasn't been, which is why so much discretion has been given to, you know, the legislature making the laws and the state executives, quote, you know, enforcing those laws. And the court system hasn't really been able to do much about it. It's whatever the government says is good, therefore it's good. It's presumed good, let's just say. And it's hard to rebut that unless and until you have the word fundamental, and it's a right that is part of our declared rights in the Constitution. So that's a big difference.
Thanks, Mel. I see that Wendy Letterman has joined us, and she has been providing me with information about her concerns. In Southeast Florida, there is a lot of talk about the privatization of water. How would our amendment come into play in such cases where there are efforts to privatize public water?
Thank you for asking, Joe. I appreciate it. And sorry, there's a little bit of noise and I have a bit of some dental issues, so I might speak a little funny. But I really appreciate you asking that. This is a great talk. So in particular, in Fort Lauderdale, they just privatized the water and they did it very deceitfully. For this specific case, and I think with a lot of privatization efforts, it's going to be local because the externalities for that specific region, say what's happening with the springs and Nestle, you know, it's just extracting too much, which tends to be pattern. But in Fort Lauderdale, and actually 1/5 of the cities in the United States, they add disinfectants as opposed to doing filtration methods that are non-toxic. And the disinfectants that they use are ammonia and chlorine. They create biofilms, they create chloramine. They have to do burn-offs twice a year for 3 weeks, where these create halogen compounds, which are just insanely toxic. And the EPA considers this like an odd, like not a normal condition, so they don't properly regulate or test for these things. And all these things, your tap water ends up in the waterways. So whatever they're putting in the waters to disinfect it, or if it's just privatized and there's no like real liability, like in our contract, it says that the water quality standards don't have to meet legal standards, only contract standards. It's an Israeli multinational corporation, so they're not even, they don't care about American laws. And so Food and Water Watch found an accelerated rate of contaminants when water is privately owned. So all of these things end up in the waterways. If we're going to be very literal about this particular amendment protecting waterways and the right to clean water. And I think you could even push it, I mean, to say like, you know, it's coming from an aquifer, we're ingesting it. I mean, if we're going to have a right to clean water, then I mean, it shouldn't really matter where it comes from. It's just access to humans having clean water. So I hope that answers properly. Thanks for asking.
Mel, do you want to address that?
Oh yeah, I'll just add that, yeah, that type of situation would definitely be within the realm of what a plaintiff can do with the amendment. It's, you know, the state is handing too much over to a private corporation. Just because they, you know, privatize, or even if they call it a delegation of authority, you know, either way, they have not shirked their responsibility as the state for keeping us healthy and safe, right? And this Constitution embraces that and promotes that reality, that truth, that basic principle. So you can totally go after the state for, you know, doing, you know, entering a contract or delegating authority or whatever that allowed for harm to be done to the people through the water. Absolutely can.
Thank you, Mel. Thank you, Joe.
Oh, thank you, Wendy, for keeping on top of that very frustrating and complicated situation out there. Sucks.
Well, another common question or concern about the language of our amendment is that there are no numerical standards in it, Mel.
Mhm.
When we're talking about a situation such as Wendy brought up, don't we have to have some sort of numerical standards that draw a line and say, okay, this is clean water, this isn't clean water, this is acceptable, this is pollution? Are our terms too general is what I'm asking.
Right. No, because the fact is that not only is every water body different, every system is different, you know, the uses may be different when you're talking about, you know, drinking supplies versus an ecosystem by itself. The bottom line is that science changes and develops. And the more we learn, the more we realize, okay, maybe it's not parts per million, maybe it's parts per trillion that we should be working in on this particular substance or chemical or whatever. And as science develops, we want that to be readily available to the plaintiff, saying, according to these studies, you know, and this scientific expert, what the state is allowing is harmful. And it's hurting these families, these end users, or whatever. In fact, you don't even have to prove the harm. You just have to show that the science points to the harm. Okay, and so we want those kinds of studies to be readily available on day one, and for the plaintiff to walk into court and file the suit saying the state is in the wrong for this particular thing that either hasn't been regulated yet, or the regulation standards are just way too wrong. You see that in PFAS family issues. You see that in a lot of the chemicals, the cocktails that are being created synthetically to replace PFAS. Now that it's on the, you know, that's being highlighted. You know that this is going to be a round 2, round 3, right? So what we want to do is make sure that the bottom line, the line in the sand constitutionally is, you can't harm us, state. You can't do that. That violates our rights. And doing so through our water is specifically, you know, prohibited. So whatever that looks like, with whatever chemical, with, you know, wherever in the state of Florida, we can now say you can't do that. And the court will agree with us.
Terrific, thanks. You're getting some applause from Casey Adams. I'm looking to see if there are any other questions. If there aren't, then I have go ahead, Casey. Cassie, sorry.
Hi, yeah. So say I'm a concerned citizen and I see a problem. Now I noticed you mentioned earlier government attorneys. What do I do? How would one start a legal action against a state agency if we see something going on? And who pays for that? How does that all work?
Sure. And this is kind of like much like other laws out there, but only this one will actually get you attention if you bring it up in public comment, for instance. You know, you can bring it up and say, hey, St. John's Water Management District, FYI, based on these studies and this evidence or this data, you're currently or about to infringe on my right to clean and healthy water. You might want to look into that. And, you know, kind of give them a heads up. You don't have to. I mean, you can take them to court as soon as you have the case ready. But to save everyone time and money, you might want to have them fix themselves from the inside, because going back to the government attorneys, they'll see what you have, what the facts are, what the evidence is, what's, you know, especially that can be admissible in court. That's what they're concerned about. And they'll advise their decision makers. Yeah, that was a valid public comment. We need to fix our stuff. And we need to do it fast. And we need to do it in a way that shows that we're fixing ourselves. Should there be another plaintiff out there ready to take us out, not take us out, you know what I'm saying? But whatever flaw, whatever mistake or whatever decision that does cause harm and does infringe on the rights of Floridians, those government attorneys have a duty to tell their client, yeah, you can't do that. Yeah, you got to fix yourself. So should there be a bad attorney, or should there be an obstinate agency leader or whatnot, and they still continue to dismiss you or just not do something that they should be doing? The next step would be probably, you know, just realistically asking a local environmental organization that has seen court time, that has had experience in litigation, and they could probably either take up the case for you or refer you to the right people, right organization for next steps. That would be probably my approach. Thanks for the question.
Thank you, Mel. Other questions?
Wendy?
Thank you. Yeah, and I could because that's like awesome advice from Mel, and I'd just like to add on top of that from someone who's like come from like having no legal experience to having to be thrown into a court system. And if for any reason you exhaust everything that Mel suggests, which is, I totally 100% agree with that. Also calling and this is for anybody in any situation, calling the county clerk or the clerk of the court that you have to go to, like, if you know what questions to ask, where they can't give like legal advice, but they can explain processes to you, like, okay, this is who you have to go see to fill out this form and etc. As long as you know what questions to ask, they're usually pretty happy to help, because they're worker class, like a lot of us are. So you know, just any kinds of questions like those, because yeah, I'm in a similar situation where I'm like wondering like what to do about this privatization thing. But definitely the environmental groups, but calling your county clerk is always not a harmful idea anyway. Thanks.
And I'll just add, that reminded me of another thing. In my career in the Marine Corps, we would always freeze up and reprioritize our worlds whenever we hear the word congressional interest or congressional inquiry. And that is what happens when a regular citizen calls their congressperson and says, what about this? And the congressperson relays it to the DOD, who then puts it down the chain of command and says, someone needs to answer this question. That was like, you don't understand how powerful citizens are when it comes to asking a question through their congressperson. Okay, that's the federal system. So back to the state system, I would think that you might not have the same system of, you know, accountability or relationships between public officials, but calling your public officials, calling your local representative or your local, your county, your city, you know, public officials have a certain clout and credibility when they're the ones making the call to the agency, saying, hey, can you answer this question for me from one of my constituents? And it probably wouldn't be them, it'd probably be a staff person, but still the same thing holds true. When the question is official, you get official answers. So that's just another way of saving money, not having to go to court and maybe getting the issue taken care of.
Thanks, Mel. Can I throw a very specific scenario at you?
Maybe.
Maybe, okay. This is something I just recently learned about. It has to do with up near the St. John's River. And I'm reading from the St. John's River Keeper website. For over 50 years, an obsolete dam built as part of the failed Cross Florida Barge Canal has been damaging the health of historic Silver Springs, the Ocklawaha River, and the St. John's. The Rodman Dam resulted in the clearing and flooding of approximately 7,500 acres of floodplain forests, while submerging over 20 springs and 16 miles of the Ocklawaha beneath a massive pool of water. The federal government eventually halted the Boondoggle Canal project, but the obsolete dam across the Ocklawaha and the impounded pool of water remain after all these years. The time has come to finally free the Ocklawaha River and reconnect the Ocklawaha, I hope I'm pronouncing that correctly because I've said it about a dozen times already, Silver St. John's River. Reaching the dam will reestablish access to essential habitat for manatees, bring back migratory fish populations, reconnect three river ecosystems and historic Silver Springs, and restore a lost riverway for anglers and paddlers from the Ocklawaha to the Atlantic. I know there are lots of people who want to free the Ocklawaha. Would our amendment be useful to that effort?
There's definitely a very strong argument for it, because there, when the state tries to develop their answer of why this is a compelling government interest, there's plenty of evidence that says otherwise. It's obsolete. It was unnecessary. There's no use in it. Maybe it's creating a lake for fishing, but that's not a compelling government interest. That is a local recreational interest. Okay, so that in that sense, I would definitely love to see this amendment being used to free the Ocklawaha. It is in my mind, in my understanding of the issues, the ecological issues, that there's continuing harm going on, even though this issue was an older issue, that the system is continuing to degrade the waters and the life in it, and that the life that's sustained from a freed river is degrading. So I would probably cite to all the studies that have been done on those issues and bring it to court. Or like I said, whoever's in charge of that decision, once they realize that this constitution is likely going to be enacted, they don't have to wait until November of 2024 to fix themselves, but they're probably going to either start correcting internally or at least covering their butts with paperwork that they're on the way, toward that end. So there's no liability involved. And again, liability is really not necessarily part of this. It's liability in this sense is really, are you violating the rights of Floridians by a policy of inaction as it regards the dam? So the answer is yes. I would think that the amendment could be very useful for that.
Just so for absolute clarification,
Yeah.
there could be examples of dams where the public interest is so great, whatever purpose the dam is serving, that a court would not compel the breaching of the dam.
Yes, absolutely. I can think of a lot of different reasons that are compelling, safety and health, drinking supplies, whatever. There are a lot of different things that humans need to survive, that a dam could directly serve the interests of. But they also have to do it in a narrowly tailored manner, meaning if they can prevent harm, they should be preventing harm in whatever aspect that might apply. It could be a design issue, it could be materials they use, it could be the location, if it's a planned dam, all those types of things have to be accounted for to prevent harm to the greatest degree. So even in those instances where there is a compelling government interest, they still have to do their very best.
Thank you. Anybody else with questions? Mel, I want to go back to a question that Cassie had asked.
Yeah.
How would a person go about starting an action with our amendment? Can you just explain exactly what the legal definition of a person is in Florida?
Sure. I probably would want to get it in front of me real quick. A person in Florida is the way we termed it, has a lot to do with what statutes already provide. So very quickly, paragraph E of definitions and subparagraph 3, person means any individual, partnership, joint venture, corporation, any group of the foregoing to include nonprofit organizations. So any grouping of what that was. So nonprofits, any tribal entity, or any government entity. So that's pretty expansive. Anyone can help keep these state agencies in check.
And if a person in any form, as just mentioned, files and wins a case under our amendment, do they end up paying their own fees? I mean, that's very expensive.
A prevailing plaintiff under the amendment is able to collect fees from the state agency. So let me look for the actual wording. But yeah, under enforcement, paragraph D, D3, a prevailing plaintiff shall be entitled to appropriate declaratory and relief and to such equitable relief as may be appropriate to remedy the violation, etc. The last sentence does go into, in addition, a prevailing plaintiff shall be entitled to reasonable attorney's fees and expert witness fees. So the basic default is that whoever wins, everyone pays their own way, right? In some statutes, and especially when you're talking about pro-development statutes, they want to scare people into saying, well, if you're wrong, you're going to have to pay the developers extraordinary attorney's fees, etc. That is, I don't know how that will go, but the bottom line for us is this is a public interest cause of action. It is, really saying, hey, state, if you're going to make us have to go sue you, then because you won't do this, your job, then you're going to have to pay for it, our troubles. And that's more incentive for them to correct their stuff from the inside as soon as possible.
So you just read from this section here and this section here and that section there. Some people say our amendment is way too long, Mel. I'm a former New Yorker, and they just passed back in 2021 their green amendment, and it was 14 or 15 words long. Is the length of our amendment a weakness? It
is how we're going to get stuff done. One of the reasons why we needed it to be this specific and this unfortunately wordy, like I said before, I would love to have had it 1 or 2 sentences long. It would not have taken months to research and draft, but the bottom line is that when we researched the Florida Supreme Court case law and we looked at all of the times that they said, okay, well, we don't like this about that ballot measure, so they kicked it, or all those reasons created this lowest common denominator type feature of a framework on how we're going to develop our stuff. So there will be 0 legal grounds for the Florida Supreme Court to kick this off the ballot. So that is one of the reasons why it was so lengthy, is because it accounted for all of those other cases that they did kick off. Another is that we have to have good standards, good definitions, clear standards and definitions to not only provide due notice to all actors, potential actors, but also to help guide the courts when they're interpreting this amendment. They're not going to have to guess too much. They can look right at it and say, yeah, that's what it says. So it's an easy application, easy day, court closed. You know, it's going to be, there's not going to be a lot of guesswork when it comes to those cases. So yes, and unfortunately, like I said, the single subject rule in Florida has been a different animal as opposed to every other state in the union. It's our Supreme Court has not been consistent. So that is the bottom line for the lengthiness of our amendment. It just needs to be, if it's going to survive Florida Supreme Court review and survive post-enactment challenges and all the above, and if it's going to serve our government attorneys out there to give them a clear and crisp understanding of standards, then this is the best way forward.
I would like to add that Florida Rights and Nature Network would never have advanced this amendment if it hadn't been as exhaustively researched and legally vetted as it was. We were not going to go forward with this campaign without getting a thumbs up on the language from at least 3 Florida constitutional law experts, professors in this case, and that's what we did. We are at 5 o'clock. Mel, thank you for all the answers today. Everybody else, thank you for being here. We return, excuse me, next week for our 4th FAQ Friday, where we're going to dive into the amendment. We will have Maya Van Rossum with us next week. We'll be talking about our amendment and also green amendments in a broader way. She'll fill us in on their application in the rest of the nation and give us a little bit more context for our conversation. So thank you for being here. I hope you'll join us next week. Have a great weekend.
Thank you.
Bye-bye.